have cool benches. And to just break that down definitionally, a hot bench is essentially a bench where you don't get to say all that you want to say because the judges are consistently asking your questions. They're clarifying your position, but you're also able to get to all the points that you want to get to in that set amount of time. So these are usually going to be your NCFCA parents that they've studied up on the packet a little bit because they have kids who are most likely competing in moot court too, and so they kind of want to understand the packet to help them out. So much more legal knowledge than these stupid high schoolers, and so they're going to try and catch you on the little like nitpicky things. That's usually what you're going to see with a hot bench. And then a cool bench is going to be the community judges who have no idea what they're doing. They just got chauffeured into the room. They got given a cup of coffee by Judge Hospitality and a ballot, and then they were told to go to room A12 or whatever. And so they're showing up. They have no idea even what the Supreme Court is. And they don't even know what the judicial system is. So they're kind of just sitting there. They're quiet. They don't really know what to do. So they're folding their hands and they're just trying to make eye contact and smile at you. So they know you're proud of them, but you're not sure why because they don't really understand anything that's going on. Or you just have a lot of pensive lawyers who are just like, yeah, I kind of want to listen to what these competitors have to say. So I'm not going to put my input in there a lot. They're going to be more focused on writing down on their ballot than actually asking questions and engaging with the material. And your job as a competitor is to make sure you're prepared for every single one of those possibilities, because those are all three a possibility walking into every single round. And what's going to set you apart is you being able to adapt to each type of these benches. So let's first talk about a hot bench, because I honestly think that these are one of the most difficult benches to deal with, just because there's so many extraneous things that you might have to account for based on a judge's preconceived notion. Maybe a judge worked on a case that has a similar problem to the case that you're debating in that given round. And so he has some knowledge on his part that he wants to cross apply into your round. And you're left thinking, well, I don't know what this guy is necessarily talking about, but he's wanting to talk about this one issue a lot. And so that's what you'll find in hot benches most of the time. So two things you need to recognize and learn and exhibit when dealing with hot benches is respect and authority. And what I mean by respect is, I mean, you embody a Supreme Court lawyer. Yes, Your Honor. Thank you, Your Honor. All of the niceties and things like that. And by authority, I mean just support for your arguments. So you're going to want to have the best cases from the highest levels of the court system. And if not, you need to have a good justification for why a lower court ruling is persuasive. But we'll see that as we get into these specific ideas. So let's start off with respect. Like I said, most of your hot benches are going to be lawyers. In fact, funny story, Josh and I, when we were competing, I think it was at the Rome, Georgia mixer, we had a super, super hotshot lawyer as our Chief Justice. Like, he thought he was the bee's knees, like, best thing since sliced bread. This guy was so full of himself. And I can remember I was getting up to speak. I was the first speaker because I think we were petitioner in that round. And I got up to speak and I was like, Your Honor, if I may proceed. And he started shaking his head. And so I started and I figured, okay, he's good with me going. But he wanted to give me verbal permission as well. And when I started, before he gave me that verbal permission, like, he shook his head and he was mad. He was pissed, man. Like, he was so upset that I didn't give him the respect that he thought he deserved, that he like marked me down on the ballot for starting before he actually gave me verbal approval, even though he shook his head. So like, you got to be super careful with these hotshot lawyer judges who think they're like the smartest people in the room or on the planet, either or. You got to be very delicate and careful and recognize that these people, I mean, they've worked a lot of their life in the law, and so obviously they do have a lot of experience, but you got to be conscious of that and be slow enough to adapt to giving respect to that legal expertise that they have. So yeah, you need to emulate a Supreme Court lawyer. That's a horrible misspelling on my part. I wrote this at like 2 a.m. last night, so ignore that. But essentially what I mean by this is you need to treat the round as if you were actually walking up the steps of the Supreme Court. You just walk through Capitol Hill, you grab your briefcase and you walk through the National Mall, and you're now facing the Supreme Court of the United States, and you're walking up those steps and you see the massive iron door. And that's the kind of vision you want to have in your mind. You enter into that room, you see these incredible legal scholars who are wanting to hear what you have to say on this issue, but at the same time, it is a fundamental honor for you to be in that courtroom, and you should treat it as such. And I think with most hot benches, you're going to have a lot of lawyers who respect the profession a great deal, and you need to bring that same sort of energy into the round. Yeah, so some community judges will not go easy on you. They will want to limit test you. They will want to see what you know, what mastery you have of the content, and they will demand your respect in the round. This isn't always the case, but I know that you should prepare for the extremes, and the extreme is they want your respect, and they want you to treat the legal profession very seriously by competing in moot court. Yeah, so like I said, law typically attracts people with abnormally large egos. That's why I don't really want to be a lawyer, not my speed. But I love moot, so it's kind of tough there. But so don't be surprised if you get pushback. The way you counteract that pushback is you listen intently. You don't talk over a hot bench. You let them finish their thoughts and even give them like a second and a half afterwards, just in case they want to add anything more. So if they ask a question and they say, you know, counselor, how does XYZ relate to ABC? And are the fact patterns in those two cases in any way analogous? You give them a second and a half, and then you say, well, respectfully, Your Honor, I'd like to point you to, you know, EFG. And then you go from there. But you want to make sure that you give them enough time to kind of to get their thoughts out into the round, and make sure you don't talk over them, because some people will take that in like a really, really wrong way, and it just won't go good for your credibility in the round after that point. So yeah, you don't want to overlook anything they have to say. Like, it's very, very important that you're listening very intently to their questions, because often they will word them really carefully, and they're kind of expecting you to overlook wording in their question that is kind of integral to what they want you to say. Like, sometimes they'll even hide the answer that they're seeking for in their own question, and if you don't latch onto that, they will push back on you even harder and keep on asking the same question over and over again until they get the answer that they want from you. So you want to take that question in stride and kind of recognize, what kind of answer are they expecting here? Is it an answer that I can concede to the bench? Is it something I should push up back on myself and say, you know what, respectfully, Honor, I don't really think that applies to the case at bar today. Though that is a valid criticism, we would refer you to the reasoning established in ABC case. So just using language like that, trying to recognize that they don't have as much mastery as the current case as you do, but they also have a wealth of knowledge as well. So you kind of need to control the narrative of the round, and you need to recognize that they're wanting to engage with your material to give you that challenge, to stimulate you intellectually, but you also need to lead them along on the right path to make sure that they're still within the bounds of a healthy debate and a healthy round. So yeah, if I may respond, Your Honor, should be before every question. If you get these lawyer judges, you should not go straight in with an answer when dealing with judges like this. You should make sure to ask their permission to even answer the question, because that goes a long way with them. I know it does on the Supreme Court as well. Another really, really important thing is, if you run into a challenging issue, you're going to have a very, very hard time if you try to sidestep that issue. So if you recognize they got you on an argument and you're kind of in that gotcha moment where, like, I don't really know how to respond to this, what you need to do is you need to respectfully concede the fact that you don't necessarily have an answer to that question. That doesn't mean you should say, well, Your Honor, and then like kind of deflect to a different issue, because they're going to want the answer that they want, and they won't stop until you let them know, Your Honor, I don't necessarily have expertise in this area, and then just keep it at that and then move on. Or alternatively, you could prepare enough so that you have answers to every question that they have. Which is difficult, but I think as you progress throughout the season and you're more invested in moot court, you'll find that you're more prepared for those kind of out of the ballpark, curveball, extraneous questions that you wouldn't have necessarily suspected receiving from a judge. So yeah, a hot bench will push you to get out of you what they want you to say. Sometimes it's just best to concede and recognize, you know what, they want this to come out for whatever reason, and your opposing counsel will probably use this in their respondent speeches or the rebuttal, depending on which side you're on. You just need to be prepared to mitigate that if you make that concession and say, Your Honor, while that may be true, we find the argument that, XYZ to be more persuasive. So you agree but outweigh, just like you would in normal debate. Don't be afraid to either respectfully tell them they are wrong using precedent or concede and move on. So if a justice is wrong who is part of a hot bench, you obviously need to do this with tact and diplomacy, but you do need to come to the table and you need to say, well, Your Honor, actually the precedent that XYZ set says an entirely different thing. And then you just need to establish the fact pattern for that case and walk them through and help them to realize why exactly their question isn't really relevant, or the opinion that they're trying to inject into the round doesn't really apply, but obviously with a lot of tact and diplomacy. Let's move on to authority. Authority is obviously really important too, because they're lawyers with sometimes 40 years of experience coming into a round, and they have a ballot and the fate of your tournament rests in their hands, per se. So they're going to think, man, these guys know nothing. They're just on the tip of the iceberg of the legal profession. So if you're going to say something even remotely controversial in the round, or something that they could push back on, you need the best precedent possible. And if you don't have the best precedent possible, you better have a darn good reason for using lower court precedent, and you need to explain to the court why they should find that persuasive. But first and foremost, even if you don't have any of those things, you can emulate the classic adage and fake it till you make it, because ultimately that's a good thing to do. Confidence is key always. So even if you're saying something idiotic and something that makes no sense, if you're confident, you'll at least sound kind of smart. And then they'll be like, yeah, but counselor, you're an idiot. And then you'll be like, you know what, Your Honor? Yes, I am. And then you'll move on. So confidence really is key. And so judges will respect your confidence if you push back on their points with that tact and with that diplomacy. Essentially, when you're in a round with the hot bench, you are trying your very hardest to earn the respect of the judges. And so as you flex your intellectual muscles, per se, they're going to respect you more and more, and they're going to give you a lot more credence to your points as the round progresses. So yeah, confidence is good. If you're nervous, totally understandable. I know going into my first moot court tournament, I was literally sleepless the night before. I couldn't get any sleep because I was so nervous. I'd never done moot court before. I'd done debate for 6 years, and I was still shaking going into my first round. But you kind of just get up at the podium, you channel your inner SCOTUS lawyer, and you just go for it. So you want to try to find ways to mitigate those nerves, because with a hot bench, nerves are going to show to that hot bench that you're not confident in your position. And that's going to help them look more, they're going to examine you more closely to find your weaknesses and press those weaknesses. So even if you don't really know what you're saying and you have no idea what in the world you're talking about, at least be confident so that they'll be much less likely to pry and find those weaknesses and exploit them for your opposing counsel. And actually, this is something that's really cool about your confidence too. A lot of the times you're a lot smarter than you give yourselves credit for. I remember at my first moot tournament, it was North Carolina National Open. I think this was quarterfinals. I was against Joshua Anamalu and his partner, and I got a really, really tough question from one of these justices who actually, I think the Chief Justice literally wrote the case packet. So that was kind of terrifying. And I was trying to deal with this question, and literally I was talking faster than my brain could process. But whatever I said in response to that question was actually an extremely good point that I didn't comprehend until after the words came out of my mouth. Literally, I came up with a great response without even knowing it was a great response. I was just talking and it came out because I was confident. And I literally used that response to every other question like that for the remainder of the season. So if you retain that confidence, sometimes your mind will even work faster than you can catch up with it. And you'll say something really smart without even trying to, and it'll be fun and you'll be good. And then you'll get all the moot points and you'll have a fun time. So yeah, confidence is key, and confidence is underrated, and it's the best strategy in every form of public speaking ever. Don't underrate confidence. So pushing back on authoritative precedent, It's obviously very, very good, as we've established already. This is self-explanatory. You guys are in the advanced section. You kind of know the fact that precedent from higher courts has a higher persuasive value than that of lower courts. In fact, higher courts have often binding precedent, which means the case at bar needs to bear that in mind, and the court, i.e. the Supreme Court, has to abide by the ruling of a court with binding precedent. So let's say you have a packet and you really want to make this argument, and this argument is only made by a circuit court. Boo-hoo. Sorry, too bad. But the language is really good, and the language is persuasive. You need to find every reason for that point or for that language or for that quote to be persuasive. And what I mean is you need to go through the fact pattern. You need to point out every single similarity that circuit court case has to the case at bar, and you need to lay that out for the justice. So, for instance, let's take last year. The Second Amendment challenge, Garcia came to the United States as a child, and he was a law-abiding citizen, and he wants gun rights. I think it was the case of Portillo-Munoz, where the fact pattern was extremely similar, and it was not a Supreme Court case, but you could link that lower precedent and make it persuasive just by saying, look, both Garcia and Portillo-Munoz were brought across the border as children. They're both productive members of society. They both have family who are U.S. citizens in the United States. And Portillo-Munoz sided with the petitioner's right to own a firearm. I don't know if that's necessarily the case. I'm just making an example. So maybe it ruled entirely in the opposite way, and I just don't have that case in front of me. But you get the idea, right? You want to take a lower court case with similar, if not identical, fact patterns to the case at bar and say, Your Honor, while this is not binding precedent, we would offer this as a persuasive ruling because of the fact that the fact pattern lines up almost directly with the case at bar. So that's how you kind of make an excuse for using lower court precedent when you can't find higher court precedent. Also, huge thing about hot courts or hot benches. You need to know the date and court of all of your rulings. If you throw out a ruling like Verdugo or Urquidez and you don't know which court decided that issue or which date decided that issue, I'm sorry to say, but you are screwed, my friend, because all of these hot benches, they're going to try and quiz you. They're going to try and get that gotcha moment with you. And they're going to say, well, counselor, how do you, or what year was this case decided and where was it decided? And they'll be like, Your Honor, I'm not necessarily sure. And then they'll be like, I gotcha. I got you. You're not as smart as you think you are, even though you're confident, but you don't know the things. And so you need to know the things. Know the things. Very important. Because hot benches are more likely than any other bench to try and get you on the date or the court location. So you should always have that like in your script or whatever you're using, whatever preparation technique you're using, you should have the name of your court, of the case. You should have the court in parentheses and then the year it was decided. That should be obligatory. Whenever you're writing any moot court material and you reference a case on paper, you should have all of those next to it so you can flip to it at a moment's notice or just memorize it. Flex your intellectual prowess and just memorize it like a cool person who is very smart. That's also an option as well. Okay, that's a lot about hot benches, and I think we're pretty good on time. I want to talk about warm benches now because warm benches are most common, honestly. So there are three things we need to deal with: concession, adaptation, and engagement. And there will be a lot of overlap, just fair warning, between a lot of these cases, just because, I mean, it makes sense that there's overlap because a lot of warm benches take elements of hot and cool to make warm. So let's start with concessions. So warm benches are often parent judges, like I said, who are looking to understand the case packet more. They want to make the round fun for you. They want to see you flex your intellectual muscles as well. But also they probably have competitors who are doing moot court as well. And they're like, oh, I want to find this really cool argument or test out this argument on this team so I can say to my students, like, hey, I talked about this in my moot round and I asked XYZ question and I thought it was really cool and you should add it to your case. So that's totally something you could add, or something that you could focus on in a warm bench round. you should capitalize on their curiosity 100%. They want this, they're trying to reach like the same conclusion that you are. They want to vote for you when you get up to the podium, obviously. And they want to kind of make some discoveries in the case packet as they compete per se alongside you. So once they latch on to a given issue and they're like, I really want to talk about de facto sentencing, then you should cater to that, and you should give a lot of precedent to support what you're saying on that de facto sentencing issue, and then indulge their curiosity and lead them down the path that you want them to be led. They are the most likely benches to bring bias into their questions. So they're probably going to enter with some preconceived notions, and they're going to want to try and prove those preconceived notions. So I actually had a judge that year I was competing who was so biased towards the respondent that she would literally make the respondent's arguments for them when she was questioning them. And then she would be super, super duper hard on the petitioner when they got up to speak. And luckily, I got her as a judge twice, and both times I was respondent. So she gave me like 50 moot points every single time, which was like super sick. And I was super happy that that was the case, but I would have felt really bad if I was on the other side of that coin. And that's perfectly understandable. It was a very charged issue like immigration that year. So you're going to have a lot of people who are leaning in certain directions, and you're going to want to try and deal with that the best way possible. You're going to want to direct them away from their preconceived notions towards the substance of your argument. You want to make sure you break down the bias that they're bringing into the round. You're going to want to say, quite frankly, you're going to want to reason with the judge and say, well, Your Honor, while this is not necessarily the most popular position, it's the most legally sound position, and here are the reasons why. And so you have to separate that, the political nature. So obviously the court should be an apolitical branch of the government. Right now it's really not, because the court system's just a mess right now. It's horrible. But the founders intended the judicial branch of our government to be as apolitical as possible. And so you want to remind them of the legal merits of arguments rather than the political notions behind arguments. And that's really, really important. You want to agree with warm benches whenever possible. I think the best part about doing that, and the most value you can kind of extract from doing that, is you want to make the warm benches feel like they're doing a good job. I know it's like, it's really meta, but the judges are only going to be as interested as they feel like they're asking good questions in the round. If they feel like all of their questions are idiotic, they're just going to sit back and they're going to be like, I'm not smart enough to ask questions and really engage with this round. So when a judge asks a good question, or even like a lukewarm, like not even that great question, but it's still like a probative question that's good enough, you should say, absolutely, Your Honor. That is an excellent question, and that is why we would direct you promptly to the ruling established in Verduga-Urquidez when they ruled XYZ. So you want to get them excited about being involved and engaging with the case material. So people like to be told they are right, and judges are no different. So if you tell them good job for pointing out or making an astute observation, they're going to be like, oh, cool, I'm actually doing a good thing in this round, instead of, asking benign questions that no one cares about. So obviously don't compromise on key elements of your case, but be sure to be agreeable. I think the most important part about being a persuasive mooter is being a mooter who can recognize the importance of their principles, but also at the same time agree with the judges and concede some ground to the other side. It makes you seem a lot more reasonable, which also makes you seem a lot more persuasive. So yeah, that's a fantastic point, Your Honor. I'm glad you brought it up. It's as simple as that. Very reasonable question, Your Honor. Allow me to answer. Let's talk about adaptation. You want to use their own words, and this is critical. And this is like the bread and butter of a great moot like competitor in every type of bench. If a justice brings something up on opposing counsel's question or in your co-counsel's question, you want to use their exact wording, not against them, but in answering their questions. So for example, you want to pick up on key language and you'll say something to the effect of, as the Associate Justice pointed out in my co-counsel's argument, ABC. Or, Your Honor, as you pointed out, or as you referenced in your questioning of opposing counsel, there is some importance and relevance to ABC. Sure, so same thing right there, yeah. So in opposing counsel's argument, Mr. Chief Justice, you raised concerns over affording Second Amendment protection to a segment of the population that consistently eludes detection. And we assure you that is a perfectly valid concern that the petitioner must address. So that would be if you're on respondent and you're listening into the questioning of the petitioner, and the Chief Justice is talking about, oh, illegal immigrants are hard to track, so maybe we shouldn't give them firearms. You bring that up on respondent and you say, you were absolutely right when you brought this up, Your Honor, and we couldn't agree with you more, and the petitioner needs to address this. Another thing that is good, giving a Fifth Amendment example, is, Your Honor, in opposing counsel's argument, you raise concerns related to the territorial jurisdiction of opposing counsel's client. We as the respondent do not believe the petitioner has proper standing to file suit due to the reasons you've already mentioned in your examination of opposing counsel. It's as simple as that. You're using their words, you're using their ideas to directly stick it to the petitioner. Let's talk about engagement. Obviously, you need a very strong presence in the room. Moot in high school is a lot less about substance than it is in college, and it's a lot more about the performative value. So you want to make sure that you have a strong, confident persona in the room. You want to make sure that everything that you say is with authority, with confidence, but you also have good inflection and good engagement with the audience and with the bench. Part of that is good eye contact. Obviously, people aren't going to want to listen to you if you don't look them in the eyes. It's as simple as that. It's just like having a normal conversation. You want to have that eye contact so you personally engage with the panel and you kind of get to share part of you with them. They understand that you're a real person because you're looking at them, and it kind of humanizes you, and it helps them to get behind you and get on your side in the round. Control of facial expressions is also really, really important. You want to make sure that you're making if you want to crack a joke in Moot, which is suspect, I don't recommend that. But if the judge makes a joke, you want to be sure to laugh and consider it to be the funniest thing in the world. Okay, maybe not, but you want to chuckle at least. You want to smile and you want to say, certainly, Your Honor, and then move on into your question. You just want to make sure that you make them feel good. That's like your goal. You just want to make them feel comfortable, willing to engage with you, all that good stuff. So you do need to have mood-based tone variance. So when you're dealing with an issue, say on Second Amendment, where I think on respondent I referenced like illegal immigrants are responsible for 700,000 homicides. I don't even know if that's correct, but you get the mood variance, right? It's a very solemn statistic, and I'm saying, illegal immigrants are responsible for 30,000 cases of sexual assault in the year of 2010 alone. You want to have that mood variance, so when you're bringing up important issues that have a lot of gravitas and weight to it, you want to denote that with your tone. So yeah, confidence when necessary, or confident when necessary, sincere when necessary. You want to recognize that some cases are going to have a lot of emotional backdrop to them, and you want to give credence to that, and you want to recognize when part of the fact pattern is pretty tragic, and you want to treat that with care. Good pacing is also really important. You don't want to go too fast. You also don't want to go too slow. You don't want to bore the panel, but you also don't want to lose the panel by going too fast. And also part of that is good enunciation. If you can do a higher rate of speed, which I was able to, I think, pretty well when I was a competitor, I was able to go at a speed that was above average, but I was able to enunciate everything, so it was easy for the justices to kind of follow. That's just my style, so it depends on what you're capable of doing in regards to pace and enunciation and things like that. And that leads us to the final type of bench we're going to talk about today, and then I'll open up for some questions. I'm not sure where we're doing on time. Actually, I got a text from Ethan. Okay, cool. We are recording on this computer. Nice. I was about to be very sad, but we're all good. Okay, so cold benches. Let's talk about them. There are two issues or two things that you need to master when you're dealing with cold benches. First is mastery, and second is delivery. So with mastery, that just means knowing the case timing of your cases inside and out. Like, that's super important, because a cold bench is going to be usually someone who doesn't ask any questions whatsoever. So it's going to be like, you have a respondent speech that's 10 minutes long. And let's say typically you get about 2 minutes of questioning per respondent speech you give. Well, what happens if they don't ask any questions? It means you're ending at 8 minutes, which is 2 minutes you could be using to make better arguments or more arguments to substantiate your claims. So you need to be able to adapt to that. And it's the same thing for hot benches too. You also need to be able to adapt to that as well and recognize when you need to jettison or ignore an argument in favor of a better, more persuasive argument. So you need to have contingency plans, and what that looks like is additional cases to reference on the back burner. You could have the fact pattern of those cases, the holdings that were in those cases. And so if you have a point that you already cite a case for, and you could say, Your Honor, in addition to this, the Zavidas v. Davis court also ruled that XYZ. So you have those additional cases on the back burner that you can use to prove the same point and support that same point a little more. In-depth fact pattern analysis is also really good. So if you're running low on time, you might want to bring up the fact pattern of Boumediene v. Bush and how like terrorists were granted Fifth Amendment rights in the United States, and walk through that fact pattern briefly, just so it takes up more time in your speech. Also on respondent, for sure, you can preempt opposing counsel's arguments in the rebuttal. You can take that time to recognize what they're probably going to cover in the rebuttal, and you can go from there. You also need to know when to move on from an argument, and this is really important too. You need to recognize what arguments are most important in your case, because very often you will find that cold benches are some of the most opinionated benches, or they're just not paying attention at all. So if they're very opinionated, they'll be like shaking your head, shaking their head no, not willing to ask questions. If that's the case. Or if you're just boring your bench, which God forbid you would do that, because you'd use good enunciation and like pacing and tone, right? You guys wouldn't bore a panel, would you? Maybe? Okay, well, you shouldn't. That's not a good thing to do. So try and prevent them as much as possible. So if an argument is boring your bench, or the bench isn't finding it persuasive, prepare additional material to move on to. So maybe if your compelling governmental interest argument isn't working on Second Amendment, you should have one other argument that you could stick in there and be like, well, Your Honor, if the court doesn't find this argument of a compelling governmental interest persuasive, we'd also like to issue this claim before the court. I remember I was doing a round, and I think I had that happen, and I came up with this really wonky argument on the fly where it's like, Garcia can self-defense. He can have the right to self-defense without having a firearm, so he could get like mace or pepper spray or like a baseball bat from the store and use that to defend himself. Just like, maybe that wasn't as well thought through as it could have been, but you get what I'm getting at. You should have another argument on the back burner that you could bring up to engage the audience and make sure you still have their attention. Also really important, signpost important argumentation so the bench cannot miss it. If they're bored, or if they're not really vibing with your arguments, you want to make sure that you are enunciating well and denoting via your enunciation what is most important that you're covering in that speech. So delivery, speed, tempo, we've already talked about this a little bit. It's so important to be slow when you need to be slow, or be fast when you need to be fast, or recognize that maybe maybe a lot of the community judges came from like a assisted living facility, and they're all over the age of like 120 years old. You don't want to go really slow for them. You want to adapt to your judges, and you want to make sure your pace fits the kind of energy you're getting from that panel. Inflection is also super important. You want to make sure that they're following everything that you're saying. That's super important too. And then finally, passion. They're not going to be passionate about this issue that you're advocating for if you aren't passionate about it either. So you want to make sure you keep that passion up for as long as possible. So yeah, that's responding to the questions. 3 most important things. Again, reading the room, coming prepared, and being flexible. So that's it for the presentation. Hopefully you guys enjoyed it. I'm open to questions now. you guys have anything you'd like me to cover a little bit more, I'd be more than happy to address that and kind of shed light on some of the things I covered. Like I said, I promise I don't bite, so.
What do you do when a justice asks you a question that you genuinely have absolutely no clue? Like they say, what about this part of the facts of the case? And you're like, I've never read that part of the facts of the case. Do you just like casually say, I don't know in some professional tone?
Yes, kind of. Like, it really depends on the question, and it depends on the bench too. Like, if it was a warm bench, you could probably say, Your Honor, with all due respect, I'm not sure I understand exactly the question, or I'm not sure I'm familiar with exactly the part of the record that you're referencing, but I would like to direct you to, XYZ case. On a hot bench, that could be seen as sidestepping, which is bad. So maybe it's a good strategy to just take the L and say, Your Honor, I'm not familiar with that. My apologies. And then just move on from there. You just have to, I know it sounds like bad because you're like not sounding as confident, but like in that position, it's better to concede that you don't know than to try and act like you know, because they'll call you on your BS 100%. Any other questions from anyone else? What are your thoughts on wood benches? I'm more of a steel bench guy myself, but I appreciate the input.
Was any bench more agreeable with your arguments, like hot, cold, or warm? Like which one was more, not really like receptive, but which would let you talk more about them, if that makes sense?
Oh, okay.
Like,
so you kind of switched up your question halfway through. So
go with the first half.
Okay, sure. I'll try and go with both, but you have to remind me of the second one after I answer this part. So probably the most agreeable benches, or like the most willing to like agree with me, have been hot benches, because hot benches are usually the very opinionated ones, and if you get them to like vibe with you and they're like, oh, his preconceived notions, line up directly with my line of argumentation, I'm like, oh, sick, this is so cool, he's gonna make all my arguments for me. And that's what happened. And then your second half of your question.
The second half would be which would let you talk more? I guess obviously cold, but yeah. Never mind the second half.
Okay,
it's okay.
Sure. I mean, warm benches were pretty good about letting me talk too, but yeah. Do we have any more questions? I think we have like a minute left. Sure.
So like, especially with a hot bench, when like you're trying to make your argument, or maybe you make your first point and then they just keep asking you a ton of questions, how do you sort of like move on to your second point or further discuss your argument if they're just asking you questions all the time?
Sure. So I think at that point you do have to cut your losses depending on where you are in your speech. Like if you're respondent and you're like in the first 4 minutes of your speech, you can definitely try and pivot to the content you actually want to cover. But if you're in like your rebuttal or whatever, or you're in the yeah, we're having a party. Hey, nice of you to show up. What are we doing?
Okay, Jack. So hello. I heard that
hey,
help.
Yeah, because I don't know what this drill is.
The drill is simply you take your case, because y'all have cases. You get like 3 minutes each, and Jack's going to ask you like 2 questions, and you practice doing what Jack has been teaching you in this last session. And Jack, you give coaching corrections. So you can go in order. So on my screen, Lexi's on top, and then David, Caleb, Zach, the Dones, and then Ava. We can go in that order, and you can have like 3 to 5 minute speeches and get interrupted by questions. Jack will give you some comments at the end. Sound good? I'll stick around here.
Sounds good. Actually, let's kind of make this a little more interesting. So we covered the 3 types of benches, right? So I want you guys to let me know the bench you're least likely to feel confident in going up against. And I'm going to give you that bench, okay? So go ahead and type in chat And actually, the order in which you guys type in chat is the order in which we're going to cover, or we're going to go through you. So whichever bench you were least wanting to deal with, we're going to do that one. Cold and hot. Okay, I'll give you a warm then. Hot. Hot. Yes, correct. You would love a hot Ethan. Okay, I'll give you the hottest bench I can offer. Okay, is that everyone? I think we had 1, 2, 3, 4, 5, 6, and that was. So we have Lexi, Caleb, David, Dennis, Zach. Okay, so we're gonna go in order. So I guess Lexi's going first, and I'm going to give her a cold bench, and you can time yourself, and I'm not giving you any protected time.
That is very scary. Okay. Let me get my phone. Okay, so I have a very rough outline with like a ton of quotes in it. I don't even know. Okay, I'm just gonna time myself.
Well, actually, that's crazy because I don't remember asking. So I'm just kidding. I'm just kidding. I'm gonna give you your warm bench. Okay, it's gonna be a lot of fun, and we're gonna enjoy it. All right.
Okay, we'll do our best.
Yeah.
I'll do my best. Okay. Mr. Chief Justice, and may it please the court. My name is Alexandra Tong, and I represent the petitioner, Miss Maria Alvarez, in her Fifth Amendment claim. Although my client is an illegal alien, according to this court's precedent in Zedvitas versus Davis, she still deserves the protection of basic liberty rights. I'll expound on this idea in 2 simple points of argumentation. First, that Miss Alvarez is indeed protected by the Fifth Amendment, and second, that the Fifth Amendment right is being violated by her detainment. To the first point, that Miss Alvarez is protected by the Fifth Amendment. Although Miss Alvarez is an illegal alien, she's not a U.S. citizen, she still has all the constitutional rights that every U.S. citizen should. The reason for this can be found in the precedent that we find in the standard found in Zedvitas versus Davis, a Supreme Court case which decided that, quote, once an alien enters the country, the Fifth Amendment Due Process Clause applies to all persons within the United States, including aliens, whether their presence in the
Counsel, I want to stop you right there.
Yes, Your Honor.
I want to clarify the date which Zedvitas v. Davis was decided, just for the benefit of the court. Do you have that date off of hand?
Yes, it was decided in 2001.
Understood. You may continue, counsel.
So Ms. Alvarez was an illegal alien. Her presence in the United States was classified as unlawful, and it was a temporary residence. However, she was found within the jurisdiction of the United States. According to the facts of the record, Ms. Alvarez was arrested and pulled over once she had entered the U.S. border.
But counsel, we can both agree that before Ms. Alvarez entered the United States and was characterized as an entrant alien, Ms. Alvarez was a resident alien who was working in the United States and who had pretty substantial ties to the United States, at least economically.
Absolutely, Your Honor. I would agree with that. In fact, that sort of helps Ms. Alvarez's case as well. If we look at the precedent as well set by this court in Yigwo versus Hopkins, which was cited in Wong Wing versus United States, they said that, quote, it must be concluded that all persons within the territory of the United States are entitled to the protection guaranteed by those amendments.
Counsel, was Ms. Alvarez intercepted at the border or within the border of the United States, or was she found trying to cross the border and never made it into the United States?
Your Honor, the facts of the record don't specifically mention where she was pulled over, but it does mention that she was pulled over, from which we can generally assume that she was probably driving once she was within the border, because the U.S. does not patrol outside of the border.
Well, counsel, isn't it true that Ms. Alvarez attempted to cross the border and was intercepted while attempting to cross the border into the United States? Isn't that the language that the fact pattern uses?
I would have to look back at the facts of the record for that. I'm not entirely sure.
Yeah, counsel, arguendo, let's assume that that was the language that was used. In that case, wouldn't you agree that Miss Alvarez never actually entered the United States, therefore was entered into custody outside of the territorial jurisdiction before she even entered the United States? Does that change the claim that's being made today?
It would change.
That's okay. It's a tough question. It's like the toughest Fifth Amendment question you could get. So
Yeah.
don't worry about it.
Isn't there like a case that says that there was someone who was outside of the border and he still had protections?
I think that's. I think Shaughnessy v. Mezzi says the opposite. Actually,
The opposite.
Shaughnessy v. Mezzi it's the Mezzi guy who's held at Ellis Island, but he's being held at a border like patrol facility, so he's not technically in the United States, and that's kind of what I'm trying to get at.
Yes. Yeah.
Okay, so now, counsel, wouldn't you agree in Shaughnessy v. Mezzi, this person was kind of in the United States, but kind of not really, and so he doesn't get Fifth Amendment protections?
Sure, but I believe that according to the facts of the record, Miss Maria Alvarez was pulled over, which seems to imply we can reasonably assume that she was within the border where the Border Patrol found her. I would have to look back at the exact facts of the record, but that is what we believe to be the case.
Understood,
However,
counsel. You may briefly conclude. Sorry for the sake of time.
That's okay. Yeah, I have 20 seconds. It is because we believe that my client does indeed have the protections of the Fifth Amendment that we should hold to the law of this country, which rules that people deserve the basic protection of liberty rights. Miss Maria Alvarez should not be held against her will within a detention center without being given the opportunity for release that is due to all persons. Thank you.
Awesome. Great job. You dealt with some really tough questions with style and grace, and I commend you for that.
Thank you. I'm rough and rusty on this case. So.
Well, luckily for you, it's July, so you have a ton of time to prepare. So I wouldn't sweat it at all.
Yeah.
All right. I think it was, I think it's Caleb next. So 5 minutes on the clock, and I will start it whenever you're ready. No protected time.
Okay, then I will begin.
Sure.
Mr. Chief Justice, and may it please the court, my name is Caleb Brown, and I will address Ms. Alvarez's Fifth Amendment claim. We ask this court to reverse the decision of the lower court because constitutional rights extend to non-citizens. 2 points, Your Honor. First, the Fifth Amendment protects entry aliens. And second, Alvarez is an entry alien. Moving to my first point. The Fifth Amendment protects...
Counsel, before you proceed with your argumentation, what standard of scrutiny are you recommending this court abide by when deciding on this case?
In this case, I'm not recommending a standard of scrutiny because I believe that in this case, the government does not necessarily have a interest in protecting or in detaining Alvarez because she's not a flight risk and that ICE has already decided that she is non-threatening.
So, counsel, are you recommending a rational basis standard for reviewing this claim?
I'm not recommending a rational basis standard because I'm recommending more of an intermediate standard because the government does not have a compelling interest.
Understood, counsel. You may continue.
To my first point, the Fifth Amendment protects entry aliens. Now, Jones versus Cunningham noted specifically that even though aliens that are outside the United States are not inside the territorial jurisdiction of the United States, as contrasted with Walling versus United States, they still have Fifth Amendment rights. They noted, citing Shaughnessy versus Maze, that even though the alien in that case was outside the state of the United States, that, quote, he still had the validity of the Fifth Habeas Corpus to test the validity of his entry into the United States, end quote. So even aliens that are outside
counsel,
the United
was that Fifth Amendment claim specifically dealing with the Fifth Amendment right to due process? Because I recognize the Fifth Amendment encompasses a lot of different issues, like habeas corpus rights. But that's not exactly the question that's being asked today. What do you say to the due process claim being raised by by yourself, the petitioner?
I would say, Your Honor, that the due process claim made by the petitioner is she's explicitly challenging her indefinite detention, habeas corpus. She's claiming that the government does not have an interest in detaining her because she has Fifth Amendment rights. So I would say that Jones versus Cunningham does still apply to the case at bar.
Understood, counsel.
Thank you. Additionally, this court held in Boumediene versus Bush that even terrorists, Algerian natives held in Guantanamo Bay, outside of the territorial jurisdiction of the United States, had Fifth Amendment habeas corpus claims.
Counsel, can I clarify the definition of territorial jurisdiction for the benefit of the court?
Yes, Your Honor. In that case specifically, which looked specifically at whether or not Guantanamo Bay was inside the legal jurisdiction of the United States, the court found that although the United States did have sovereignty over Guantanamo Bay, i.e. because we have a treaty with Cuba, it was still not inside the officially recognized aspect, the territorial boundaries of the United States, and therefore the aliens held in Guantanamo Bay were not part of the United States.
So for instance, say a military base in Okinawa, Japan, that wouldn't be considered the territorial jurisdiction of the United States by the definition set by Boumediene v. Bush?
It would not, Your Honor. Even though the United States does control the limited base, it's not officially recognized. You can't go to a map and actually see it.
Understood.
And so, since the Fifth Amendment does protect entry aliens, not merely just resident aliens or citizens, it's clear that it would allow Ms. Alvarez, if she is an entry alien, to claim habeas corpus rights and challenge her indefinite detention, which leads me to my second point. Ms. Alvarez is an entry alien. Now, Ms. Alvarez was apprehended at the border, and the government in the lower challenging of the court and the petitioner have scuffled over whether or not she's actually inside the territorial jurisdiction of the United States. But this court has ruled twice that explicitly applied to this case would show that Ms. Alvarez is indeed an entry alien. The first is Lang May versus Barber, which held that even though a entry alien was allowed on parole into the United States, she still did not come within the territorial jurisdiction of the United States.
But counsel, you're aware of the fact pattern, and you even referenced that in your reasoning where you said that she was intercepted at the border, right? She never made, at least the fact pattern would suspect the fact that she never actually set foot in the United States. She was apprehended when trying to climb a fence or pass through a gate or what have you.
Yes, Your Honor, that is correct. Even the fact pattern of the case itself indicates strongly that she is indeed outside the United States. Ms. Alvarez does have constitutional rights. They apply to all non-aliens. Thank you.
All right. Good job. Yeah, I really liked your fielding of questions too. Your mastery of the content is very evident. You had a lot of great case citations, so good job on that. David, my man, step up to the plate.
Alrighty.
I'll start the timer when you're ready. And you least want a hot bench, right?
Yes, least one. All
right.
And this will be petitioner, just for the reference.
Sure. I'm finna grill you, homeboy.
All right, sounds good. Mr. Chief Justice, may it please the court. My name is David Weiner, alongside my co-counsel, Ms. Alexander Tong, represent Mr. Garcia and Ms. Alvarez, the petitioners in the case at bar. My co-counsel will be addressing the Fifth Amendment issue, while I will be addressing the issue of the second, specifically relating to Mr. Garcia. Justice Singer, the right to self-defense is not unique to the citizens of the United States only. On the contrary, it is one that is granted to any quote-unquote people and persons on United States soil. Make America Safe Again Act undermines the rights guaranteed under the Second Amendment in two ways. Mr. Garcia's Second Amendment rights have been violated for two reasons. The first is because the Second Amendment protects, quote, people and persons, not just citizens, end quote, which the Act seeks to undermine. And the second is that the Act interfered with the right of self-defense, which the Second Amendment guarantees to the petitioner. In reference to the first point, the Second Amendment protects people and persons, not just citizens. The Second Amendment says, and I quote, "The right of the people to keep and bear arms shall not be infringed," end quote. For instance, Your Honor, both non-citizens and aliens are generally allowed the rights to free speech, privacy, due process, etc.
Certainly, counsel, but we can agree that the First Amendment and Fourth Amendment rights, they don't really have a bearing on the ability to take a life of another person. The Second Amendment is unique in the fact that it gives someone the right to carry a weapon that could easily end someone else's life, correct? And shouldn't there be a different emphasis placed on this issue as a result?
I agree with you to an extent, Your Honor. While yes, there is a difference to an extent between the Second Amendment and the First and Fourth in relation to their content, it is not our stance as the petitioners that we should draw lines in between of what rights should apply to non-citizens and what rights shouldn't, because at that point it could possibly be considered discrimination depending on what rights are allowed to who.
Well, what about amendments to the Constitution that grant individuals the right to vote? Obviously, we don't want to grant the right to vote to non-citizens, don't we, counsel?
Yes, Your Honor, including felons, but that isn't necessarily the stance of the petitioners today.
Right, but you're making a distinction to say that we shouldn't discriminate against individuals based on their immigration status. Can't you agree that the Bill of Rights and furthermore the Constitution at large does make a clear distinction between those who are in the United States and those who are naturalized citizens who are corresponding to the government of the United States?
Respectfully, Your Honor, I must disagree. It is not our contention that the issue of the Second Amendment is discrimination against minorities or aliens. It is rather that applying some rights to some people but excluding some rights to others sets a dangerous precedent going forward for both non-citizens and citizens alike.
Counsel, respectfully, I don't see the difference between those 2 points. I don't see a difference between the quote-unquote discrimination that you characterize and also just treating people differently based on their immigration status. Why is it not within the government's authority to decide who gets what rights based on what sort of official connection they have with the United States proper?
Respectfully, Your Honor, it is our contention that the Constitution grants rights, but it is not necessarily the power of the government to limit those rights to others and choose who they want to give out some rights to and choose who they want to take rights away from. The Constitution simply grants these rights. It is the power of the government not to decide who gets them and who don't, rather to restrict them in the right circumstance. We believe the Second Amendment is no different regardless of the content. And while I agree with you that obviously the ability to take a life is to an extent more serious than the right to free speech and the right to due process, it is still no different in the eyes of the petitioner when it comes to illegal immigrants. Both are equal rights that should be granted to both. And we can look at the case of U.S. versus Vertigo Urdiquez, decided in February 28th of 1990, where it says, quote, for instance, the Fourth Amendment phrase, the people, seems to be a term of art used in select parts of the Constitution in contrast with the words person and accused used in articles of the Fifth and Sixth Amendments. This suggests that the phrase, quote, the people, refers to a class of persons who are part of a national community or who have otherwise developed sufficient connection with this country to be considered part of that community.
But you're saying, counsel, you're saying that it's valid enough to work a job or have family in the United States, and that's something that should supersede the privilege of a right granted to citizens. Is that what you're saying?
Yes, Your Honor. It is our contention that Mr. Garcia is undoubtedly a part of that political community, as mentioned in Vertigo Urdiquez, as he has been a resident of the United States since the age of 3, has graduated both high school and college, and is already on his—
that still doesn't make Mr. Garcia a naturalized citizen. And I recognize you're low on time, so you may answer that question and briefly conclude.
Yes, Your Honor. It is simply our contention that since he has developed specific connection to this country, such as graduating college, obtaining a job, and close to obtaining citizenship, that while he is not officially a citizen of the United States, he has developed a sufficient connection to this country. And for that reason, we request this court overture.
Got it. Okay, I think we have time for one more. Can you guys remind me who was supposed to go next?
I can go next if no one else wants to.
Sure, we can do that. Totally.
Yeah, let me get my...
I'll have my timer ready too.
Okay. So this is Second Amendment petitioner, but my computer malfunctioned, so I didn't hear anything that David said, so don't worry.
Okay, cool. Perfect.
All right.
Feel free to start whenever. And actually, before you start, you struggle with hot benches. Got it. I'll give you a hot bench.
Mr. Chief Justice, and may it please the court. My name is Ava Allen. My co-counsel, Emerson Allen, and I represent Mr. Dominic Garcia and Ms. Maria Alvarez, the petitioners in the case at bar. At this time, the petitioner would like to reserve 3 minutes for rebuttal. My co-counsel will address the Fifth Amendment issue, and I will address the Second Amendment issue. Today's case contains the idea that provisions in the Bill of Rights should apply to all people, not just citizens. regarding the Second Amendment issue. First, the Bill of Rights applies to members of the political community, as established in Heller. And second, Garcia is a member of the political community. Thus, his Second Amendment right is violated.
Counsel, how do you respond to the precedent set in District of Columbia versus Heller, where it says that the right to keep and bear arms and the right to self-defense are inextricably linked to citizenship?
Respectfully, Your Honor, that does not specifically regard to immigrants into the United States. And if we look at the case law established in the case after that, Heller versus the District of Columbia, it took the position that the Second Amendment extends not only to citizens, but also to individuals within the political community. And this decision relied heavily upon the United States case, United States versus Verdugo or Quitas in 1990, which defined the political community as all residents who have developed a sufficient connection within this country.
Certainly, counsel, and my apologies for the miscitation of the case on my part. I meant to refer to United States versus Huitron-Guizar when they were commenting on Heller versus District of Columbia. You would agree that the court ruled in the 10th Circuit, Huitron-Guizar, that it is not exactly reading between the lines to note how frequently the opinion in Heller connected arms bearing and citizenship, right? And what is your response to that?
I'm not completely sure that I understand your question, Your Honor.
Essentially what I'm asking is, what is your response to the 10th Circuit Court saying or commenting on the DC versus Heller decision to say that arms bearing and citizenship are inextricably linked?
To an extent, Your Honor, that is a correct position. All citizens do have a right to bear arms. That does not mean that non-citizens are devoid of that.
So you're arguing that the 10th Circuit is not necessarily arguing the link between citizenship and gun rights to the exclusivity of that group?
Yes, Your Honor. It's not an
Understood.
exclusive right specifically to citizens.
I'd love to see some substantiation for that, but you're free to continue.
All right. By looking at both the text and the history of the Bill of Rights, it indicates that Garcia is among those meant by the people, as denoted in the Constitution. In the case United States versus Portillo, I don't know how to pronounce that, I apologize, Portillo Munoz, the court has never held that the people is specifically meaning one thing in certain amendments and something different in other amendments.
Counsel, I want to push back on that point, because actually the same court case of United States versus Portillo Munoz, the Fifth Circuit Court ruled that, quote, illegal aliens are not law-abiding or responsible citizens or members of the political community, end quote. What is your response to that?
I do apologize. I'm not sure I understand.
So the same court that you referenced, Portillo Munoz, to say that the people is referred to as the same in those different amendments, that Fifth Circuit Court also ruled that illegal aliens are not law-abiding or responsible citizens or members of the political community. What do you say to that? And why should we accept the validity of your claim using that case when they obviously